This is only take 5. I don't know what we're worried about.
Is this episode 3?
This is episode 3, take 5, version 3.79er.
All right, so shall we?
Yeah. Our new fancy equipment, our new studio.
New seating arrangements.
New seating arrangements. We got a
So-
microphone check.
We're here today, GRL Law Raw, bringing you episode 3. Today we're going to be discussing the title, Above the Law.
Above the law.
Talking about some special treatment that law enforcement officers have through our legal system. And today we're going to focus a little bit more on that, talking about some different types of immunity. We've heard that term a lot recently.
Yeah, and I think what's happening is under the current public discussion that's rightfully happening, and action needs to be taken more than just discussion, but people are starting to pay attention, look for, and understand the underlying mechanisms that result in the disparate treatment and really facilitate police misconduct and governmental misconduct as well.
Yeah, I mean, the movement, as I see it, really is boiling down to a call for more transparency from police and more accountability. And kind of last episode, we talked a little bit about some things that we might be able to do to look at making situations that are frustrating people a little more transparent. This episode is a little bit more on accountability and how we can go about that or attempt to go about that and some of the hurdles that exist.
Yeah, because without the accountability, without consequences to misconduct, that misconduct is always going to continue. They get away with it.
Right.
And they get bolder, things get worse, and then we reach a flashpoint where we're at right now where people have had enough and aren't going to tolerate it anymore, and changes need to be made.
Yeah, and so last episode, just a little bit of a recap, we were discussing criminal cases and issues that come up in criminal cases that frustrate people, and the kind of the discretion that officers had and how that discretion was being exercised potentially disproportionately amongst minorities, and how that was feeding the frustration. So we talked a little bit about pretextual stops.
Perfectly okay. Perfectly acceptable.
So, the situation where an officer can say, yeah, I stopped this gentleman because he was black, but I'm okay doing that if his registration sticker was on the wrong side of his license plate. Though that situation was a lot of last episode, but
courts have said, just to recap, courts have said that is constitutionally permissible.
Right. Whether rightful or not, they have. We talked about issues centering around mistake of fact, where you've got an officer who mistakenly says, I did not see or hear or whatever the situation is correctly, but the courts have still upheld the officer's action taken because of the mistake made by the officer.
And what we're seeing is a double standard in the law, right? Citizens do not get a mistake of fact defense to anything.
Right.
Oh, I didn't know she was underage. Oh, I served that person alcohol but didn't know that they were under 21. That's not a defense for normal citizens, but it is a defense for law enforcement when they are alleged to have violated somebody's constitutional rights.
Right. So again, that's kind of feeding into this title and this theme, above the law. It feeds into the frustration with the lack of accountability. And then the real potential frustrating topic that we touched on last time was mistake of law issues, where an officer can be mistaken in what the law actually says, believes he's taking action that is in accordance with the law when in actuality he or she is not. But some courts have even said that's okay.
And again, citizens presume to know the law. You get that thrown in their face all the time, but law enforcement who's trained to enforce and to know the law in certain jurisdictions gets a pass for mistake of law. Thankfully not Iowa, but federally in Iowa it exists, and in other states it's a real problem.
The mistake of fact, mistake of law issues reminds me of that case we had with professional poker players that were coming through Iowa, and were illegally stopped, and the Attorney General's office was trying to argue both mistake of fact and mistake of law issues
For not using their blinker?
for not using their
When
blinker.
they did use their blinker?
Right.
That they claimed, well, they couldn't see it, so it's a mistake of fact. Well, the law wasn't clear, so
Clearly
it's a mistake of
established,
law,
right.
which will
We'll feed into a little bit more
qualified
here.
immunity, correct.
And then, the one thing we didn't really touch on last episode, but came to light as we talked a little bit more about this, is the good faith exception. Under the federal Constitution, where officers who execute a search warrant, even if the search warrant is defective for some reason, but they, in good faith, relied upon the warrant, again, no harm, no foul kind of situation for them.
And so what we see building up is a frustration within the criminal justice system where a double standard exists for law enforcement, where people are being incarcerated, they're being convicted of crimes, they're being thrown in prison, even based upon mistakes by law enforcement or improper motivated conduct by law enforcement. And the courts have said, yeah, sorry,
Right.
it's okay. So you have that underlying frustration, and then we get to a situation like we're going to talk about today, which is the frustration within the civil justice system.
So let's get into that a little bit. We've been hearing the words immunity a lot lately. And what is immunity, and are there different types of immunity?
There are a number of different types of immunity, but immunity is in essence a complete bar on being sued. So the person can file a lawsuit, but if immunity it's a defense to the entirety of the action against the person. So if they can prove the defense, the lawsuit stops there. It doesn't get to a jury, no jury determination at all. Poof, gone, away and done with.
So, classic situation, somebody comes in and wants me to represent them because they believe that their civil rights were violated by a police officer. We have
Excessive use of force. Somebody got beat up by the police.
Excessive use of force. Got beat up by police. I mean, George Floyd situation. So, we got a couple of things to look at. Number one is, who are we going to sue?
Yeah.
Is it going to be the police department? Is it going to be the individual officer? Is it going to be somebody else? And then we've got to wade through issues of immunity. So let's talk about each one of those scenarios quick.
And before you even get to those situations, we have to establish that a constitutional right was violated. And this takes us into what we talked about last episode. I found this looking up some information for this episode. It's by Justice Rehnquist in the case of Baker versus McCullen, which really highlights, like we talked about the last episode, which is if an officer says, I stopped that person because of their race, absolutely, I'll admit to it. But I had a factual basis to show probable cause for a traffic violation, it's inconsequential, right?
Yep.
And Rehnquist flat out says in the opinion, the first inquiry to any Section 1983 suit, that's the federal law that allows these suits to be filed, is whether plaintiff has been deprived of a right secured by the Constitution and laws. If there has been no such deprivation, the state of mind of the defendant is wholly immaterial. Boom. You don't even get a civil lawsuit out of that.
Completely feeding the justification that you hear, I was stopped for driving while black,
Yeah.
or stopped for driving while Hispanic, whatever the situation may be.
Yep.
The Supreme Court said, yeah, well, that's okay.
Point out probable cause, you're okay,
Right.
officer. But then we get into, all right, who do we decide to sue? How do we sue them?
So jumping back to that excessive force scenario, you come in, you want to sue the police department, the police officer for this excessive use of force. How do we go through that? Let's talk about let's take the city police department first. How do we wade through that?
In any civil lawsuit where you sue someone, the goal is always to find a greater legal entity as opposed to an individual, right? For example, a business, an employer, because in most situations, an employer is responsible for the wrongful conduct of their employee that occurs during the employment process.
And they may have some type of insurance coverage that an individual wouldn't have, and there's potentially a better avenue or way to recover some type of compensation for the harm as opposed to going after the individual.
Certainly more assets,
Right.
Certainly more ability to pay for any damages that have occurred. For example, you get rear-ended by a UPS truck. You don't necessarily just want to sue the UPS individual driver. UPS is responsible for the negligence of their driver conducted within the scope of their employment.
Right.
In most situations, that's the case.
But not here.
Not here.
Not here.
Not with law enforcement.
Right. And one of the first hurdles we have to get over is the government consenting to being sued, right?
And that's where that comes in, because under the 11th Amendment, the states have sovereign immunity, and a lot of that, so you can't sue the government unless they first agree to be sued and give you permission to sue them.
And that consent to sue that we're talking about comes from statutory enactments by the government, which essentially say in these situations, we will allow suits to proceed against government entities if these things have been met.
Correct.
All these preconditions and these procedural milestones and all these different things.
And that's where this defense that cities have as employers of officers who commit misconduct is the U.S. Supreme Court looked at the consent statute, section 1942 U.S.C. 1983, which is the law that gives people the ability to sue government entities who violate constitutional rights. And they said, listen, yes, that's all good, but it only applies to the individual who commits the wrongful conduct. So unless you can show that the employer, the city, has engaged in wrongful conduct that is separate from the officer's conduct, you don't get to sue the city. You don't get to sue the employer.
So, let's again assume we got a situation where we can fit the city into this consent to sue scenario, proceed according to the statute, and we get the lawsuit filed. What's the first thing the city's gonna scream?
You can't prove it, because really what happens is, in order to get the city on the hook, you have to show a pattern in practice of allowing or facilitating or encouraging the unconstitutional behavior. And so that's where it comes into play of, well, you can't show that this has happened before, or you can't show this has happened repeatedly and we haven't done anything about it.
Right.
There's a problem there.
And the problem is that it encourages them to not be transparent. It encourages them to take these scenarios and sweep them under the rug so that nobody knows about them, not put a formal complaint in writing, not whatever the situation may be, because they don't want a paper trail. They don't want any evidence
Pattern in practice
for an attorney to get a hold of to show a pattern in practice. Because if they can't show a pattern in practice, then the city is going to proceed to win most of those suits on the merits because we're unable to show that pattern in practice.
So what happens is a supervisor, a sergeant, or somebody sees an officer do something wrong, sees an officer use excessive force, maybe rough somebody up after they arrested him. Instead of filing a formal report and going through the chain of command and having documentation, just pulls them aside and said, hey, don't do that again.
Yep.
And what happens? Nothing.
Nothing.
So you actually incentivize, the way the law exists right now, cities, employers, police departments are actually incentivized not to document and to take disciplinary action for misconduct.
Right. And not only does it incentivizes the police department itself not to keep track and document these things, but it really isn't any type of deterrent to the officers either, because what happened? Oh, I used excessive force. Well, no, what happened to you? Oh, I just got pulled aside and told not to do that again. I mean, there's no accountability on the part of the department towards the officers.
And that's where citizen complaints become so important.
Right.
That's where it is so imperative. Even if a person isn't going to file a formal lawsuit or take any formal legal action, if they believe an officer treated them improperly, if they believe excessive use of force was used, if they believe there was racially motivated behavior, a written complaint needs to be filed with the department, because that can't be swept under the rug. It has to go in the file. There has to be some tracking of that complaint.
And I would add, not just to the department. I mean, UCC,
everybody.
Everybody on that.
Yep.
The city attorney, the mayor, whoever is in that chain.
The officer's mama.
Right.
I mean, whoever you can tell about it
Or
needs to be told
supervisor,
about it.
everybody. Yes. All right. So that's. I mean, I wonder what the theory behind that rule is, or that maximum in the legal system.
Well, one is that they just interpreted the statute as written, and it appeared to the Supreme Court at the time to say this is, you got to show an independent wrong by the city in order to be liable. But what may not have been considered at the time, but what should be considered now, is there is a psychological impact on a juror or a jury.
Absolutely.
To be looking at it saying, listen, I don't want necessarily Officer Jones to have to pay this $1 million or $100,000 for beating this person up and causing serious injury.
He's got a tough job. He's got a wife and kids.
Couldn't do the job myself, which is true for most people. But so it's the individual is the face as opposed to the corporation or the organization or the government entity, which has a minimizing impact on the ultimate compensation for damages that they would otherwise decide.
It's the same type of scenario when you have a car accident and we have to sue somebody because they caused a car accident and damages to somebody else. When that case proceeds to trial, the person sitting in the defendant's chair is that individual, not the insurance company representative. You don't get this big sign that says the person paying for the damages is American Family or State Farm or whatever. The jury is believing that it's the individual paying,
right,
not the company.
And you're not allowed to mention it. And in
Right.
these situations, the city actually, even if they're not individually responsible, they still have to indemnify the officer. In other words, cover any damages that the officer would otherwise have to pay. But nobody gets to know about that either. It's a little dirty little secret.
Hey, all interesting. So what's this deal with absolute immunity?
It's gross. It's terrible. It needs to go away. It's not going to go away.
How does it work? Let's take this scenario. Let's say that you come into the office and you want me to represent you on a criminal charge, and part of the state's theory is you did it. Several witnesses saw you did it, and my theory is it wasn't you. We've got an alibi. Mm-hmm. And ultimately the case proceeds to trial, you get convicted, and you go sit in prison.
Yeah.
5 years later, as we're working through the appeal process, we get documents, and lo and behold, there's a statement from an individual who says, I looked at a photo lineup, Mr. Ray Kemper did not do it. And that gets swept under the rug and never disclosed, intentionally swept under the rug and never disclosed to you after charges have been filed.
Prosecutor could know about it. Prosecutor could intentionally hide it within the judicial process, and if the misconduct occurs as an integral part to the judicial process of the prosecution, even if a prosecutor makes the intentional decision to prosecute somebody knowing that they didn't do it or knowing that there's not probable cause, for example, DNA exculpates them and they have it, don't disclose it, the prosecutor is absolutely immune from misconduct that occurs within the judicial process.
So by taking an active role in hiding exculpatory evidence, which potentially caused you to go sit in prison for a period of time, you have no recourse against that prosecutor.
Yep.
Well, your recourse is file an ethical complaint.
You file an ethical complaint, they get a wrist slap, nothing happens to them. But they are immune from suit for strategic and discretionary decisions in the prosecution. This also goes for investigators, witnesses, judges, other types of situations where you can really come up with some scary situations. There's a separate action for somebody who's wrongfully convicted that you get paid a little bit, but you can't hold the offending prosecutor or even the offending judge or the offending witness legally responsible if it happens within the judicial process.
Now, let's be clear. The example I gave there is an extreme example.
Sure.
And
but don't think it doesn't happen.
Right. But I guess we don't want to discourage people from doing nothing about those situations. I mean, those are situations that need to be vetted by an attorney to see if there is a way around this absolute immunity.
And there are arguments, for example, if it occurs in the investigative stage, that they are not immune from misconduct in the investigative stage. It's within the judicial process. There's arguments that it didn't involve the judicial process or was outside of the judicial process. There's arguments to be made, But the concern is a license for misconduct. We could almost retitle this segment a license for misconduct.
Wow. And the same would hold true, if a judge was involved and encouraged the prosecutor to throw that evidence away.
Or say we've seen this on national news, coaching, right? There was that case where the judge was coaching the prosecutor.
Was
during
texting
trial.
him or something, right?
Correct.
Yeah.
Within the judicial process, immune from suit.
Crazy.
Yep.
All right, so then that covers absolute immunity, which is gross. But what about qualified immunity? How does that all play out? And let's jump back to the scenario where you come in, the excessive use of force. We want to sue the city. We've talked about having to work through the pattern and practice stuff there, that the city potentially would have to jump in and pay for any damages that we were able to show the officer caused. But how does this concept of qualified immunity work in that scenario?
It's yet another hurdle. It's yet another hurdle that the government or law enforcement agency and officer get to throw up. Primarily, and we can talk both federal and state jurisdictions, right? Because we can sue in federal court or we can sue it in state court, and the standards are different.
Right.
But what's getting the attention now is the qualified immunity within the federal courts. What qualified immunity is it's an affirmative defense for the officer to put up, saying, listen, I didn't know better, so I can't be held responsible because it wasn't a clearly established constitutional right I violated. I didn't know better. I didn't know.
Yeah, so we talked about the poker boy case.
Correct.
And that case, we ran into this argument being advanced, and ultimately we were able to settle the case out. But the issue there was whether or not the officer was justified in stopping the vehicle of these two gentlemen for failing to use a turn signal when changing lanes. And there was an unpublished Court of Appeals case that says you don't have to use a turn signal when changing lanes. Well, their first attempt was, well, the officer didn't see it. They tried the mistake of fact. Well, you see the video. It's pretty dang clear on the video that,
Yep. But the video doesn't always capture what the eye captures, right?
Right,
Yeah.
right. And then they fell back to, well, that case is not a clearly established law because it was an unpublished Court of Appeals case, so we may have this qualified immunity that applies to us.
So they were arguing that they did, and it's always there because constitutional rights, there's always some wiggle room or arguments to be made on
A little factual
any
difference
side.
here. A little.
So what they argue is, well, it wasn't clearly established. Like you have to for example, it wasn't clearly established that I couldn't whack him 12 times
Right.
over the head with a baton. The case that exists that says you can't beat somebody up with a baton involves somebody who took 20 lashes.
Right. Or, yes, you can't hit this guy when two hands are handcuffed behind his back, but if only one is handcuffed, then it's open season.
And those are the arguments that get made, and they get bought in federal court, and these cases get dismissed. Reuters did a big investigation on it, and it's available online for people to see. But how egregious some of the misconduct is that gets dismissed. The civil lawsuit gets dismissed under this qualified immunity shield.
Right.
And then to add to it, if the officer loses in the district court level where they try to throw the case out on summary judgment for qualified immunity, they have the absolute right to an immediate appeal. The case doesn't even go forward to trial as it otherwise would. It's an immediate appeal to the appellate court right off the bat.
And that process generally doesn't exist for anybody else. I mean,
nowhere.
Yeah.
Nowhere.
Well, so the clearly established constitutional right language is in the federal system.
Yes.
State system's a little bit different.
Thankfully.
Right. And there's a little better standard or higher standard that officers are held to under the state constitution.
And this is actually a developing area of law because some smart and forward-thinking attorneys and judges have looked at these issues and say, you know what? Like we've been doing under state constitutional defenses in criminal cases, the federal law sucks. The federal law is unfair, it's unjust, it doesn't comply with what we expect for citizens in Iowa. So we're going to make these claims for violations of a separate constitutional provision, which is the Iowa Constitution.
And what's the standard under the Iowa Constitution? Well, let me back up. The reason there's a different standard is because the Iowa Constitution has been interpreted to provide greater protections, or can provide greater protections to citizens of Iowa than the federal counterpart.
Correct.
And so that's why we got this differing standard there. So what is that standard?
And what the court said is, when these cases came up, that didn't know, we're not tolerating that in state court in Iowa. Instead, what we're going to say is qualified immunity can exist for claims of constitutional violations if the government official can prove that he or she exercised all due care to conform with the requirements of the law. So it's an elevated standard if you're going to use qualified immunity in state court in Iowa that is significantly more difficult to throw out than in federal court.
So in Iowa, it has to be the law. It doesn't have to be clearly established constitutional right that's violated.
And the defendant has to be able to show, listen, I did everything in my power to make sure I was complying with the law. And if I didn't, I don't get to, if they can't make that burden, then they can still be held civilly accountable for it.
And so some of these cases, I think you and I would both agree, when these cases come in the door, probably first approach here is to look at advancing an Iowa constitutional claim, because that might be the less burdensome route to go.
There is one downside to the Iowa constitutional claims, which is that currently Iowa does not have a mechanism like in federal court for attorney's fees for the wronged party. In federal court, if you prevail as the wrong party, you're entitled to be reimbursed your attorney's fees. In state court, that's not the case. So those minor violations that don't result in serious bodily injury or death or significant damages are less likely to be taken by attorneys from an economic decision, as opposed to in federal court, where all I got to do is show a violation occurred.
But that's certainly something the legislature could revisit and add that provision to allow for attorney's fees for those.
And that would be a positive change. We have good case law under the Iowa Constitution, and if the legislature truly wanted to do something about the qualified immunity issue or protecting the constitutional rights of Iowans, all they would have to do is adopt a statute, a law that says if a person is shown to have had their constitutional rights violated, they are entitled to reasonable compensation for attorney's fees.
Yeah. So
it's an easy fix.
Going back to last episode, one of the solutions we had proposed is requiring all police interactions, traffic stops, to be recorded and documented and maintained in a database to help wade through some of the pretextual issues, the disparity and discretion being exercised by officers. So there was a database to evaluate that. One of the things here as an additional solution to help, that was a transparency solution. Yep. This is more of an accountability solution, is have the legislature jump in and provide attorney's fees for these constitutional violations under the Iowa Constitution, just like the federal counterpart.
And it wouldn't take much. The wording is already there in the federal statute. Right. All they got to do is cut and paste and run it through the House and the Senate.
Well,
one more solution. Solved.
When you step back and look at this, it's easy to see how there is this mounting frustration from, the inception of a traffic stop who the person felt was disproportionately picked out from others, all the way up through having to try to get compensation to justify a constitutional violation. It's just an insurmountable mountain, it looks like, from somebody who really doesn't understand and appreciate how to navigate up that mountain.
It's an uphill battle. It's an improper double standard. It's certainly not something that can't be overcome. And in fact, more claims should be made. Attorneys should be more aggressive in pursuing these. Right. There should be more assertiveness on the part of society in general to encourage these claims to be made, because these lawsuits truly do have the ability to force change. Yeah. And if you don't force change, things are going to continue the way they are. Speaking of forcing change, the next thing that we talk about in the next episode is probably going to get a few people a little riled up.
And this will be basically part 2 of taking off of Above the Law, episode 4. And you're talking about the law enforcement officer's Bill of Rights.
Bill of Rights. Yep.
Well, we're about out of time here, so we'll wrap this episode up. But make sure you like and share, give us some comments if you're looking for different topics, and stay tuned for episode 4, where we can kind of explain and further investigate what this law enforcement officer Bill of Rights is and how that is further adding to this belief that law enforcement officers are somehow above the law.
Appreciate you guys tuning in. Talk to you next time. See ya.